Hi, everyone. I'm Kim Straker, and I would like to welcome you to our HR Forum event today. We have three very interesting and timely topics to cover. I'd like to introduce you to my colleagues, Bernie Olshansky, Nick Lucier, and Lotus Cannon, who will be presenting today. I'll be moderating the Q&A. We have a PowerPoint that we've prepared to help you follow along during our discussion, and we'll be emailing you a copy of that PowerPoint after the event so that you'll have it. First, Bernie will be discussing the pending bill in New York that could broadly ban non-compete clauses. Next, Nick will give you a practical primer on how to spot traditional labor issues and avoid pitfalls when litigating employment law cases or negotiating settlement or separation agreements. Last, Lotus is going to discuss the Pregnant Workers Fairness Act and the several nuances that employers will need to know. She'll also provide a quick reminder to you on the lactation accommodation requirements and New York PFL updates. If you have any questions during these three presentations, please put them in the chat box. I'll be monitoring that chat box, and we will try to address all of your questions at the end of each presentation. If we can't get to any of your questions or all of your questions during our designated hour, we've also set aside additional time for Q&A after our HR Forum event concludes. And we're doing that by way of breakout rooms. So when the presentations are over, you'll see a pop-up on the screen and you can join any of those breakout rooms where you'll be able to ask your questions live to either Bernie, Nick, or Lotus. And if you're unable to join us in those breakout rooms, you can, of course, feel free to call or email any one of us with your questions. Also, we wanted to let you know that we're recording this event so that we can send out the recording to those clients who couldn't be with us today. I will be announcing the CLE code later for those of you who would like CLE credit. And with that, I would like to turn it over to Bernie to begin. Thanks.
Thanks, Kim, and hey, everybody. I will be talking about the pending ban on non-compete agreements in New York State. So we can move on to that first substantive slide. So I'll start with a little overview of the status of the law, and that's going to be a somewhat major caveat. The law is not yet in effect, and if it does take effect, there could be some meaningful changes to some of the substance on which I'm about to present. The bill passed both houses of the New York State Legislature in June of this year. It's currently pending before the governor, but it's not yet on her desk for signature. The legislature must either quote unquote deliver it to her, or she can call it up for review and signature. So if the legislature does deliver it to her, the governor has 10 days to act either way, either sign or veto. If the governor does not act, it becomes law automatically. Alternatively, if the governor calls it up, she has until December 31st of this year to do that. And she can do that as an alternative to it being delivered by the governor and can act on it accordingly. There is a chance that this bill dies on the vine and doesn't ultimately become law before this December 31st, 2023 deadline. The governor has expressed support for a general non-compete law, but as I'll describe, this bill is written in a pretty severe way with limited exceptions, which might be too much for the governor to sign as is. In addition, the lack of movement since the legislature's passage of the bill in June of this year is an indication of the potential failure of this bill. One would assume that if the legislature and governor were on the same page and ready to pass this, it would have already been delivered and passed, but the delay is an indication of some legislative or lobbying and wrangling that could prevent a signature and this bill taking effect as is. Still, though, we wouldn't foreclose the possibility of a new bill, either that the legislature drafts or that the governor changes, that would be more limited in scope, which I'll describe on the next slide, so we can move there. So definitions-wise, there are two main components. There's the definition of non-compete agreements and the definition of covered individuals, which you'll see are fairly broad. So a non-compete agreement is defined as any agreement or clause contained in any agreement between an employer and a covered individual that prohibits or restricts such covered individual from obtaining employment after the conclusion of employment with the employer included as a party to the agreement. There's a lot there, but the key parts of that as it currently reads are the word any. So the definition starts off with any, indicating that this does not need to be a freestanding or titled non-compete agreement. It can be part of a broader agreement. And then this definition also includes prohibits or restricts, which leaves room for interpretation and thus could be interpreted pretty broadly. Covered individuals are any other person who, whether or not employed under a contract of employment, performs work or services for another person on such terms and conditions as they are in relation to that other person in position of economic dependence on and under an obligation to perform duties for that other person. Again, a lot there. A key here is the lack of limitation to employees. This definition includes anyone who, quote, performs work or services for another person. So that's something to be mindful of. In addition, there's no prohibition, as the bill is currently written, of post-employment covenants like confidentiality and non-solicitation clauses. It's silent as to each, so we read the bill to permit those. Also, a note on retroactivity: the bill is not retroactive. It only applies to contracts entered into or modified on or after the effective date. So once the bill is signed, it will take effect sometime after, and it will only impact laws or contracts entered into on or after that date. And then just a quick note and a refresher on the state of the law on non-competes in New York as they are now. There are 4 requirements for a non-compete provision in New York to be legal. Currently, non-competes are only allowed and enforceable to the extent they are necessary. 1, necessary to protect the employer's legitimate interests. 2, do not impose an undue hardship on the employee. 3, don't harm the public. And 4, reasonable in time period and geographic scope. So as I've noted, this law would pretty drastically change that and would preclude non-compete agreements and wouldn't give employers the ability to craft them in a way that would pass muster. We can move on to the next slide, which will be pretty brief. The penalties here include, as currently written and obviously subject to change, they empower aggrieved people with a private right of action and liquidated damages of up to $10,000. So no small penalty here. And then we can move on to the final slide here. A few common questions that we've received with regard to the pending bill. Obviously, it's tough to know, whether the governor will sign it. So this is all assuming the bill will turn into a law. Most pressingly, we see financial services clients using these types of agreements, and these typical agreements are seemingly covered completely by the law. Because of the currently broad definition of non-compete agreements, it currently doesn't look promising for those in the financial services industry. So, if the current definition remains, as you'll see on the slide, we recommend choosing Connecticut law or another state that's defensible and favorable. California, which, was one of the main states prohibiting non-compete agreements, carves out financial services from the covered industries. So, it's possible that New York could do the same in the final version signed by the governor. either through the governor making her own changes or, lobbying efforts resulting in the legislature tweaking it or the governor doing it herself. This bill also covers all workers, regardless of position or level. So, it would be possible for a future version of this bill to carve out, certain categories of employees based on, their expertise or what's required in a certain job description, or based on a monetary or salary threshold. We're not seeing that language in the law, in the bill as written. So that'll be something to keep an eye on if this bill is ultimately changed. And then finally, the concept of a garden leave in which an employer has, an employee have made the decision to separate employment, but for a period before the end of that employment, the employee is not, working for the employer, but is still being paid by the employer and is still quote unquote employed. We don't see that as being covered by this non-compete ban, because in such a situation, the employee is still employed by the employer there. The bill notably relates to prohibitions after the conclusion of employment with the employer, and a garden leave in which that employee is still employed by the employer doesn't fall into this post-employment banned category. So, with that, the brief overview of this law, I will toss it over. I think it's to Nick, and I'm happy to answer any additional questions either through the chat or in the breakout room following Nick and Lotus. Thanks.
Well, perfect. That's hard to sort of follow, to be honest. I know that issue is on a lot of people's minds right now, but what I want to talk about, hopefully pretty quickly, I'm going to try to get through it pretty fast, are sort of traditional labor issues and how they clash with what we sort of call employment law. Before I do that, I just want to say a quick thank you to the people behind the scenes, our marketing and our tech folks who are making this all possible. A huge thank you to them. But sort of delving into it really quickly, one of the big things that we fear are the things that we don't know. And I'm hoping what I can do through this presentation is sort of describe, from the labor side, things that might not be on your radar that actually move over and implicate things on the employment side. For a lot of people, the Wagner Act, which is the NLRA, and the Taft-Hartley Act, which is the LMRA, are those sort of unknowns for people who are traditionally in the employment sphere. We historically keep the employment and labor sphere sort of separate. Some people cross over between the two, but I'm hoping we can make some of the unknowns in the labor sphere known after this presentation. So, as I said, labor and employment seen as distinct things. Employment tends to be very broad, right? We can go through the endless subjects from discrimination, overtime, exempt workers, independent contractor, wage and hour, disability laws. All these things sort of fall under the grand umbrella of employment law. But I would note that at this point, given who the general counsel at the NLRB is, the labor sphere is expanding, and it's expanding rather quickly. So this world that we think of as kind of tucked away into the side is slowly growing. And, we see this sort of trend in history oscillate between, a board that's a little more reserved and a board that is more has a more expansive view of labor law. And right now we're definitely in that expansion point. But I would just note that if you are somebody or who's working for a company and you don't have a union, this presentation still very much applies to you, given what stage we are in with the NLRB right now, viewing the law as expansive and as touching non-union settings. And by the way, we are getting a way higher number of complaints coming to the NLRB from non-union settings. But I just want to go briefly into sort of the foundational laws that we have. And first, I'll talk about a little bit of history. So labor history in the United States is very, very messy. We started like in the late 1700s with loose associations of people. This moved to certain labor actions being called conspiracies. The idea was that, workers working together to try to increase their wages, that was a conspiracy, a criminal conspiracy. And we moved from that to more formal organizations, things resembling unions today. They had strikes. employers then entered the injunction phase of labor history. That was in like the early 1900s going to the 1930s. The government responded with the Norris-LaGuardia Act and the Wagner Act in the late 1920s and into the 1930s. So the NLRA, the National Labor Relations Act, prescribes the rules governing workplace-related interactions between employers and employees and unions in this country. The brunt, what we hear about a lot, is Section 7 and Section 8 of the NLRA, which enumerates the specific union-related rights of employees in the workplace. And so under the Wagner Act, under the NLRA, employees enjoy the right to join or assist labor organizations to bargain collectively through representatives of their own choosing for the purpose of collective bargaining. Some examples of running afoul of those rights would include threatening employees with consequences if they support or participate in a union, retaliation for supporting or being associated with the union, spying on employees' union efforts, or disciplining employees who engage in protected activities. We usually refer to a nice acronym or a nice a phrase, TIPS, right? So no threats, interrogation, promises, surveillance, those sort of things tend to run afoul of Section 7 rights. Employees can take complaints to their local regional director, who can investigate and at times take further enforcement action. Next slide, please. Perfect. So a lot of labor history is a response to things that are going on. The LMRA was a response to what was perceived as unions getting too much power under the NLRA. So the Labor Management Relations Act amended the NLRA, including providing certain limitations on Section 7 rights, such as by giving employees the right to refrain from union activities. And it also cemented the preeminence of federal law over the traditional labor field. Among other provisions, Section 301 of the NLRA provided federal removal jurisdiction for contractual violations. So suits for violations of contracts between the employer and a labor organization, thinking collective bargaining agreement, could find it, and it would now be brought to federal court. And there's a good policy reason behind that. It's basically that by providing removal to federal court, it ensures a uniform interpretation of collective bargaining agreements across the country, and thereby promotes a peaceable, consistent resolution of labor disputes. Federal courts have developed a common law to sort of govern the the bargaining agreement and the interpretation thereof. It is the grievance process within the collective bargaining agreement and not the court who has the authority to interpret the contract in the first instance, but the courts are there as sort of the backstop, and they will be there to sort of enforce any inconsistent interpretations of the law. Next slide, please. This all comes under a test. Basically, the general test in most circuits determine if a state rule or claim is preempted under Section 301 is whether the cause of action asserts a non-negotiable state law right relating to employers or employees independent of any right established by contract, or instead whether evaluations of the state claim are inextricably entwined with consideration of the terms of the contract. So the Ninth Circuit sort of articulated this in a nice way. We have two prongs. Does the claim seek purely to vindicate a right or duty created by the CBA itself? If so, then the claim is preempted and the analysis ends there. But if not, we proceed to the second step and ask whether a plaintiff's state law right is substantially dependent on analysis of the CBA, which turns on the question or turns on whether the claim cannot be resolved by simply looking to versus interpreting the collective bargaining agreement. So the first part of the test is much easier to understand. If a claim is derived from the right of the CBA, or from a right the CBA provides, the state law does not, and the state law does not, it will be dependent on the CBA, and the claim is preempted. The second part of the test is much more difficult. It's less clear cut whether to distinguish between merely looking at a clause and interpreting a clause, right? So that creates some headaches, as you can imagine. Next slide. So turning sort of to the pre-litigation aspects and how labor law might actually influence pre-litigation, specifically like an EEO investigation. Most employment litigators understand that when an employee makes a complaint regarding policies such as anti-harassment or discrimination, other workplace policies that might be applicable, the employer will be required to conduct a prompt and effective investigation. Depending on the jurisdiction, an investigation may serve as a complete or partial defense to any subsequent civil action, right? So employers may elect to do the investigation in-house, have outside counsel conduct such an investigation. If outside counsel does the investigation, the employer may attempt to keep the investigation under privilege, such as the attorney-client privilege or work product privilege. So now it's time to talk about something that is in this realm of expansion right now before the NLRB, and that's Weingarten rights and non-union settings. So a lot of people kind of have a sense of what Weingarten rights are. It's less understood what labor issues must be considered in employment law, an employment law aspect when you have Weingarten rights being implicated. So the rule generally comes from an NLRB case, a Supreme Court case, Weingarten, and essentially provides that a union employee has a right to be represented by his representative if he or she has a reasonable belief, or he or she may be subject to discipline as a result of the investigation. The general rule is that the employee must ask for the representation. Once requested, a failure to provide a representative is an unfair labor practice under the Act and may impact any potential discipline. Over the years, like I said, the NLRB has sort of oscillated back and forth on Weingarten rights and whether they apply to non-union employees. There's been a few cases. There was one in 2000, one in 2004. More recently, there was a case, I think in the middle of 2022, where the board basically was considering the issue, but ultimately decided the time wasn't right, or the case wasn't right, rather, to actually decide the issue. But just keep in mind that this will almost certainly come up before the board in the future. And when it does, I would put my bottom dollar on them expanding Weingarten rights to non-union settings explicitly. And it's possible they might even provide for greater entitlements under Weingarten as well. In unionized settings where you do have a union, although Weingarten rights, are understood by litigators, the union setting provides another pitfall, and that comes under a case called Johnny's Poultry. Johnny's Poultry doctrine is sort of like an Upjohn warning of sorts. It provides that employers may, or an agent of the employer may not interview an employee about a pending board matter or arbitration without providing the employee with certain disclaimers, right? So participation has to be voluntary. Participation may cease at any time. And they also do have to, by the way, tell them the purpose of questioning as well. Like I said, it sort of resembles a Upjohn warning, but the warning does need to be given at each interview. So, you have 3 different interviews sort of investigating what the underlying knowledge is of this person. You have to give them that warning at each interview. And there is board law on that as well. And I should mention that Johnny's Poultry hasn't just been, it's not just limited to board complaints, but it's also pending arbitrations and other hearings is when if you're investigating those or matters related to those, you do have to give the warning there as well. Next slide, please. Perfect. So assume you got through Weingarten and Johnny's Poultry, no issues, and now you have a deposition in a non-union related matter. Let's say it's a wage and hour matter, and you start asking questions that may implicate Section 7 activity. Well, what happens then? Well, the board sort of told us in 2003, and has since sort of reinforced that there is a 3-part test that you need to consider when you're going to be asking questions in a wage and hour case that doesn't really touch on union activity, but you want to ask questions that may actually implicate Section 7 rights. So first, the questions need to be relevant, determined by the law of the forum state. Second, the question must not have any legal objective, for example, seeking to chill Section 7 activity by outing the identities of people who may be, organizing for a union. And finally, and third, sorry, just lost the employer's interest in obtaining the information must outweigh the employee's Section 7 rights under the Act. So in Guest, the employer was deemed to have violated the Act during a deposition in a workers' compensation case by asking the employee to reveal the identities of employees who attended a union meeting. And so consistent with what I said before, we want to be careful about asking people to unveil the identities of people who might be union supporters, even if, by the way, it's within the realm of relevance under the federal rules. You could still hypothetically run into a guest violation. Next slide, please. So Garmin preemption, I say a postmortem. This one is one of a little bit debate, but the general rule about Garmin is that Section 8 of the NLRA vests enforcement power in the NLRB and prohibits unfair labor practices, interference with union activity, strikes, elections, et cetera. And that provision has been interpreted to preempt state law when claims that arise out of disputes between labor and management. This is different than the LMRA removal. Preemption is the idea, right, that the federal regulation of the collective bargaining relationship and disputes between employers and labor unions falls under the exclusive jurisdiction of the LRB. The LMRA just simply provides removal jurisdiction to federal courts. So this is different. And I should note that there was a Supreme Court case. I don't think we need to get into it for the purposes of this presentation, but there was a Supreme Court case that just touched on the Garmin preemption just recently. We can go to the next slide. So I just want to sort of really quickly talk on this, mnemonic that I made in response to a recent decision from the NLRB under McLaren. So settlement and release issues in employment litigation. We're seeing a lot of questions of people who read the McLaren decision and its prohibition on certain non-disparagement clauses, other kinds of clauses that are common to settlement agreements, and what is actually allowed. And so I spent a good amount of time trying to come up with a good mnemonic so people could remember the kind of clauses that are sort of at issue here. And so I came up with naughty dogs chase birds, some prefer catching cats. And there's a nice list of the agreements that are sort of in the general counsel's aim with respect to settlement and release issues. She is making it very clear that she wants these agreements to be narrowly tailored, and she doesn't want anything that is outside the scope of that litigation or dispute to be encapsulated in a release agreement. So non-competition agreements, non-disparagement, cooperation, broad liability releases, solicitation agreements, poaching agreements, covenants not to sue, and confidentiality agreements are some of the sort of clauses that were specifically chosen or sort of singled out, if you will, after the McLaren decision by the general counsel, the NLRB, to sort of look out for. So, if you do have these sort of stock provisions that you throw into a settlement agreement, you definitely want to give them a review in light of the McLaren decision. And I just want to make one last sort of closing point. I know I skipped a couple things because I want to be respectful of Lotus's time and give everybody ability to ask some questions. But I just want everybody to know this is a recent development. There was a case from the NLRB, Stericycle. It's putting a lot of people it's alarming a lot of people in union and non-union settings because it's a new work rule decision that says that if an employee could reasonably interpret a work rule to have a coercive meaning, and that leads to a chilling effect on protective activity, that rule will be presumptively unlawful. And I just want that to be on people's radar. If anyone has any questions about what that might mean, please definitely come into my break room, ask some questions. We can talk about Stericycle and how to read that decision. And I will turn it over to Lotus.
Actually, you know what? Thanks, Nick. Before Lotus begins, I just wanted to announce the CLE code, and that is SS as in Seyfarth Shaw 6114. So again, SS as in Seyfarth Shaw 6114. That's the CLE code. And if anyone has questions, please don't be bashful, put them in the chat box because I'm monitoring that chat can answer those questions. But you can also, of course, opt into the breakout rooms afterward. All right, so thanks, Nick. And now we will turn it over to Lotus.
Thanks, Kim. So I'll be covering the Pregnant Workers Fairness Act, which is brand new federal law with pretty big implications for employers. Next slide, please. It went into effect on June 27th. So as I said, brand new. And it requires employers to provide reasonable accommodations to employees for known limitations related to pregnancy, childbirth, or related medical conditions. What employers are covered, basically the same as Title VII. So employers with 15 or more employees, both in the public and private sector. What employees are covered, all employees, doesn't really extend to independent contractors, but part-time employees, seasonal employees, as well as applicants are covered under this law. So this law is, largely modeled on the ADA. The intent was really to kind of close the gap, that existed before this on a federal level in terms of providing, the right to reasonable accommodation to pregnant employees where the condition that was related to pregnancy didn't rise to the level of a disability under the ADA. And, so the law really adopts a lot of the definitions of the ADA, including, reasonable accommodation, what is an interactive process, and what constitutes an undue hardship, which is, truly an employer's sole defense under this law. And as with the ADA, it's a pretty high burden to meet. And requires an employer to show that the requested accommodation that's denied would cause the employer significant difficulty or expense. And this, is largely related to an employer's, finances. So larger employers will have a higher burden to meet. Next slide. Okay. So the PWFA requires employers to provide reasonable accommodations. What does it prohibit? So the first, obviously, a failure to provide a reasonable accommodation unless it poses an undue hardship. It also prohibits employers from requiring employees to accept an offered accommodation other than that's a result of engaging in an interactive process. It also prohibits employers from denying employment opportunities to employees and applicants based on a need for reasonable accommodation. It also prohibits requiring an employee to take leave, either paid or unpaid, if there is an alternative reasonable accommodation that can meet the employee's need. And finally, it prohibits taking adverse action with respect to the terms, conditions, and privileges of employment based on the requested for accommodation. So this law provides for, the whole panoply of damages, as you can see, front pay, back pay, compensatory damages, punitive damages, attorney's fees and costs, and injunctive relief. I will note that the law also provides, similar to the ADA, a provision that states that damages will not be awarded if the employer can show that they've engaged in an interactive process with the employee and have made a good faith effort to try to accommodate the employee. So basically, this tries to cover instances in which an employee engages in the interactive process and makes a good faith effort to accommodate, but the reasonable accommodation that they end up with is not actually effective. So damages would not be awarded in that case. Next slide. So now we'll discuss, some similarities and differences with the federal laws that existed in this space prior to the PWFA. And really they're just the Pregnancy Discrimination Act and the ADA. So the Pregnancy Discrimination Act really just prohibits discrimination based on pregnancy, childbirth, or related medical condition. And that also prohibited employers from refusing an accommodation to a pregnant employee if they provided the same accommodation to a not pregnant employee with a similar work limitation. So really it prohibited a disparate treatment in how accommodations were administered. versus the PWFA actually creates for the first time on a federal level an affirmative obligation to reasonably accommodate employees for pregnancy or pregnancy-related conditions. The ADA, there's a lot of similarities between the ADA and the PWFA, as we've covered, as we've touched on briefly. But there are also some key differences. One key difference is that under the ADA, it only requires reasonable accommodation for employees that have a disability. So they have to meet this definition of what a disability is, which is a physical or mental impairment that substantially limits a major life activity or a major bodily function. And not all pregnancy-related conditions were covered under this definition. Some, for example, gestational diabetes may have been covered. However, uncomplicated pregnancy or other conditions such as morning sickness or swelling and related to pregnancy would not be covered. The second main difference with ADA is who is a qualified individual. Under the ADA, to be a qualified individual, the employee must have been able to perform the essential functions of their position with or without the accommodation. And this was another affirmative defense. This is another affirmative defense to employers that can show that even with any accommodation, the employee cannot perform the essential functions of their position. The PWFA differs in this respect because employers still have to provide a reasonable accommodation to an employee, even if that employee is unable to perform an essential function of their job for a temporary period, as long as it could be performed in the near future, and as long as the inability to perform the essential function can be reasonably accommodated. What is a temporary period and what does in the near future mean? It still is a little bit up in the air, but we'll get into the EEOC's proposed regs that were released last week that give us some insight into what these terms may mean. Next slide, please. Okay. So getting into the EEOC's proposed regulations, which were released just last week. Right now we're in the 60-day period for comment, and the final regulations should be published by December 29th. So these regulations, I think they're about, they're over 270 pages. So to kind of spare you having to read through all of that, we're going to go over some takeaways right now. So one thing that really stood out from these proposed regs is that it provides for a very, very broad definition of the covered physical and mental conditions that arise before, during, and after pregnancy. Super broad definition, including current pregnancy, past pregnancy, even menstruation, fertility treatments, endometriosis, and other conditions. So it's an extremely broad definition that covers essentially any condition that bears any relation to pregnancy or potential pregnancy. And it could be potentially an unprecedented breadth of conditions that are covered under this law. And also includes pre-existing conditions that are exacerbated by pregnancy or childbirth may also qualify. Again, these are all proposed regulations that we're covering, so these will likely be revised before by the time the final regulations come out. But this is kind of the best indication that we have at this point of what the implications of this law will be. Next slide. Okay. So another big takeaway is when can an employer request documentation? And there are some important restraints on this. An employer may only request medical documentation to support a request for accommodation if it is reasonable under the circumstances. The circumstances must be reasonable, and also the requested medical documentation must be reasonable. Reasonable documentation is defined as documentation that describes or confirms the physical or mental condition, confirms that it is related to, affected by, or arises out of pregnancy, childbirth, or related medical conditions, and that confirms that a change or adjustment is needed for that reason. It's also important to note that the proposed regs provide some examples in which requesting any documentation would not be reasonable. One of the circumstances is if the pregnancy or the condition and the need for the accommodation is obvious. Another circumstance is if a pregnant employee requests one of the types of reasonable accommodation that the proposed regs deem just reasonable, basically on its face, absent extenuating circumstances. And this would include requests for increased restroom breaks, a request for breaks to eat or drink, and for an employer that's typically required to sit, to stand, and vice versa. So, and again, in all these instances, there's always, the affirmative defense that the employer has to show that the requested accommodation would pose an undue hardship. But of course, as we've covered, it's a pretty high bar to meet. The proposed regs also define what temporary means and what in the near future means. And in the near future is designed to be generally 40 weeks from the start of the temporary suspension of an essential function. So, very broad definition again here of what temporary and in the near future is. And the proposed regs also state that this time frame might be able to reset post the period of pregnancy for the postpartum period. So in that instance, an employee might be granted a reasonable accommodation under this law that in which they are unable to perform one of the essential functions of their job for 40 weeks during their pregnancy, and then they give birth, and then the 40 weeks would reset. So they would have to be provided another accommodation for another 40 weeks in which they would not be able to perform an essential function of their job for that postpartum period. And the EEOC right now is inviting comments on how this term should be defined, what should it be actually for the postpartum period, should it actually be greater than 40 weeks, and should it potentially be a year? And so again, there are some big implications here for employers, not only in the breadth of the types of conditions that are covered, but also and the fact that the reasonable accommodation has to be offered, even with this caveat that the employer cannot perform one of the essential functions of their job, but also that this period in which they can't perform the essential function of their job would span for quite a lengthy time frame. Next slide. The proposed regulations also provide a non-exhaustive list of possible examples of what reasonable accommodations might be. So increased breaks, or allowing an employee that typically sits to stand, vice versa, schedule changes, remote working, etc. And of course, with any of these reasonable accommodations, again, the employer has that undue hardship defense. Next slide. Okay. So now we're going to dive into some of the differences, similarities and differences between the PWFA and the New York state and city laws with regards to accommodations for pregnancy. And there are some big similarities in that both under the New York state and New York city laws, the pregnancy-related condition does not have to meet the definition of a disability like under the ADA, and also it requires some sort of an interactive process. However, there are key differences. One being, as we've covered with the ADA, the difference that employees must still be provided a reasonable accommodation if they're unable to perform an essential function of their job for a temporary period. Whereas under the New York State human rights law, that was still a requirement that an employee had to still be able to perform the essential functions of their job with or without the accommodation. Another big difference is the instances in which an employer can request for supporting medical documentation and the type of documentation that they can request. which differs in a large way to the New York State human rights law, which provides that, you know, an employee must cooperate in providing medical or other documentation that's, you know, necessary to verify the existence of the disability or the pregnancy-related condition, and that's necessary for the consideration of the accommodation. Whereas, as we've discussed, per the proposed regulations, which again need to be finalized, an employer can only obtain medical documentation if it's reasonable under the circumstances, and there are actually, you know, some specific circumstances in which it would not be reasonable. And then finally, you know, the potential venues in which employees can bring an action is now, you know, expanded to not only the New York State Division of Human Rights or a state court, but now the EEOC and the federal court. Next slide, please. So similar to the New York State human rights law, there are a lot of similarities between the PWFA and the New York City human rights law, in that, again, you know, the New York City law also covered pregnancy-related conditions that did not rise to the definition of a disability. Depending on how, you know, the final regulations come out, the PWFA has the potential to be broader in its coverage of you know, potential conditions, but we'll have to see on that front. The New York City law also requires an interactive process or a cooperative dialogue with the employee in order to reach the reasonable accommodation. And similar to the New York State human rights law, there is a key difference in that under the New York City human rights law, the employee must have still been able to, with or without the accommodation, satisfy the essential functions of the job, versus the PWFA provides, you know, the potential for an accommodation even where an employee is unable to perform an essential function of their job for the temporary period. And then there's also this difference, this kind of nuance in the circumstances in which an employer can request supporting medical documentation. The New York City human rights law is more restrictive than the New York State law in that, you know, an employer typically may not request supporting medical documentation unless, you know, it fits into one of the following circumstances. One being that the employee is requesting time away from work, other than the presumptive 6 to 8 week period, or that an employee is requesting to work from home. Whereas the PWFA has, you know, a different analysis here, and when an employer may request supporting medical documentation. And again, this is an area that, you know, it's still a bit unclear while we're waiting for the final regulations on how it'll pan out. But based on the proposed regulation, you know, there are some pretty large restrictions on this, and there's that reasonableness threshold that employers will have to meet to justify the request for documentation. And finally, again, with the New York State human rights law, this, you know, the PWFA kind of expands the potential venues in which employees can bring their claims. Okay, next slide. Okay. So now with you know, little time we have left before we get into our breakout rooms, I'm just going to touch on some updates on the required accommodations for lactation. So the first is this amendment to the New York labor law that went into effect on June 7th that requires employers to designate a room or location for employees to pump breast milk, and also to adopt a policy for a lactation policy. And for the location, the pumping location has to meet these requirements. It has to be in close proximity to the work area, well lit, shielded from view, and free from intrusion of other persons. It also has to include at a minimum, you know, the following things: a chair, small table, nearby access to running water, an electrical outlet if the workplace is supplied with electricity. The DOL actually issued a model lactation policy, which employers must adopt or prepare a policy that meets or exceeds these requirements. Number one, it has to inform employees of their rights under this law. Number two, it has to specify the means by which employees can make requests for a room or other location to express breast milk. And number 3, it requires the employer to respond to the request within a reasonable time frame, not to exceed 5 business days. Okay, and this policy also is required to be distributed to employees both upon hire, upon return from childbirth, and also to be distributed to all employees annually. Next slide, please. So now we're going to cover the Pump for Nursing Mothers Act, which amended the FLSA to provide employees with reasonable break time to express breast milk for 1 year after the child's birth. So under this law, employers are required to provide a space other than the bathroom that is shielded from view and free from intrusion of coworkers and the public, in which an employee can use to express breast milk. An important note is that while these protections were previously available for non-exempt employees, the Pump Act essentially closed this gap for exempt employees and provides these protections across the board, regardless of exemption status. The breaks are not required to be paid, with the following exceptions. If the non-exempt worker is not completely relieved of their duties for the entire break period, it has to be paid. Or if they take their break to express breast milk during an otherwise paid break period, then they also must be paid for the entire break. And the second is, of course, exempt employees should not have any deductions or reductions to their salary, regardless of whether they take breaks to express milk. Okay, next slide. Okay, and finally, we'll just very quickly touch on this update to the New York paid family leave. Number 1, the major difference is that the definition of family member has been expanded to include siblings, both biological or adopted, or half sibling or sibling, effective January 1st of this year. Another 2 differences are that the maximum weekly benefit to employees has increased to $1,131.08. And also the employee's contribution rate has decreased to 0.455% of their wages, up to an annual maximum of $399.43. Okay, and with that, that concludes my portion of the presentation. So I'll hand it over to Kim.
Great, thanks, Lotus. Great. So one question came in about whether there's a requirement to have a standalone written policy regarding PWFA if an employer feels like it's already covered in their other policies under reasonable accommodation.
So I don't believe there's actually a requirement to have an independent policy, but we just recommend that employers take a look and review at their existing policies just to make sure that they cover any nuances there and any differences in terms of the reasonable accommodation process. But also, we'd recommend that, they provide a separate form for a reasonable accommodation under the PWFA than the one under the ADA.
Great. And also, they are required to post notices, I know, right? So yes. And I think that there should be an updated poster on the EEOC's website for,
yes, that's right,
for employers. Another question just actually came in. This is regarding lactation accommodation, regarding the nearby access to running water requirement. If there are employees on 2 different floors, is it enough or sufficient to have running water on one floor? Or do you have to have, like where you say the proximity, or do you have to have running water on both floors if you have a lactation accommodation room on both floors?
I'm actually not sure about that one.
It's a nuance. Yeah. I mean, look, I think that probably has, it definitely hasn't been vetted yet with what constitutes really proximity. But I think that that could be something that employers could discuss with their employees too, if they feel comfortable, going from floor to floor as well. One last question came in about whether the law varied much from the existing New York City law. I don't know if they're talking about, maybe they're referring to the pump act. I'm not sure if they're referring to the Pump Act or the PWFA, but I'll just encourage you guys to join the breakout room with Lotus and ask your question directly to her.
Yeah. I can just say with regard to the Pump Act, I think there is just a lot of overlap with the existing New York City requirements there. So there aren't really any huge differences versus if the question is about the PWFA, as we covered, there's a lot of overlap, but there are those key differences where the PWFA seems a bit more protective.
Right, great. Well, thank you, everyone. I think that there aren't any more questions that came in the chat box, but please join us in the breakout rooms if you have additional questions. Lotus, Nick, and Bernie will be there, willing and able to answer all of your questions. And thank you so much for joining us, and we look